I was standing on my porch watching the sunrise over 300 acres of Texas Hill Country when I saw the first bulldozer roll onto my land. For a second, I thought I was still dreaming, but the rumble of diesel engines shook the coffee mug in my hand and confirmed this was real. My name is Marcus Garrett, and I had inherited this ranch outside of Fredericksburg from my grandfather 6 months earlier. 300 acres of beautiful rolling hills, cedar trees, and open grassland that had been in our family since 1947. The property was remote, peaceful, and completely mine. Or so I thought. I walked down from my porch toward the fence line where a crew of workers was unloading equipment. A woman in a crisp white polo shirt and khaki pants stood near a pickup truck, holding a clipboard and barking orders at the workers. She had that particular haircut that screamed she wanted to speak to the manager, blonde with chunky highlights and cut short in the back. "Hey," I shouted, climbing through the barbed wire fence. "What the hell is going on here?" The woman turned to me with a smile that did not reach her eyes. "Good morning. You must be one of the residents. I'm Patricia Henderson, president of the Silverdale Estates Homeowners Association. We're beginning construction on the new community golf course today." I stared at her like she had just spoken in a foreign language. "Community what?" "This is my property. You're on my ranch." Patricia's smile tightened. "I think there's been some confusion. This land was designated for community amenities in the Silverdale Estates Development Plan. We have all the necessary permits and approvals." "Lady, I don't know what Silverdale Estates is, but this is the Garrett Ranch. My family has owned this land for almost 80 years. You need to pack up your equipment and get off my property right now." She pulled out a folded map from her clipboard and thrust it toward me. "This entire area falls within the boundaries of Silverdale Estates HOA. When properties in this region were subdivided 15 years ago, this parcel was included in the association plat." I looked at the map. It showed a sprawling development with dozens of lots, streets I had never heard of, and a large green space labeled Community Recreation Area that seemed to overlap with a portion of my land. But it made no sense. I had the deed to my property. I had paid the property taxes. This was definitely my land. "I don't care what your map says. I have the deed to this property and it says Marcus Garrett owns it, not some HOA. Patricia's expression hardened. "Sir, I would suggest you review your property documents more carefully. We've done our due diligence, and we have every right to proceed with this project. If you interfere with our construction, we'll have no choice but to take legal action." "You're threatening me. You're on my land with bulldozers and you're threatening me." One of the construction workers, a heavy-set guy with a hard hat, approached us. "Miss Henderson, we ready to start clearing?" "Yes, proceed," Patricia said without breaking eye contact with me. I felt my blood pressure spike. "If one tree gets cut down, I'm calling the sheriff." "That's your right," Patricia said coolly. "Though I should inform you that the sheriff's department has already been notified of our construction schedule. We're operating completely within the law." I turned and walked back to my house, my hands shaking with anger. This could not be happening. I found my phone and called the Gillespie County Sheriff's Office. The dispatcher was polite but unhelpful. "Yes, sir, we have a notation about construction at that location. Do you have an emergency? There are people trespassing on my property with heavy equipment." "If there's a property dispute, that's a civil matter, sir. You'll need to contact an attorney." I hung up and immediately started searching through the metal filing cabinet in my grandfather's old office. The room still smelled like his cigars and leather. I found the deed, yellowed with age but clearly legible. It described the property boundaries in precise detail using meets and bounds, referenced old survey markers, and showed my grandfather's name, then my father's name through inheritance, and finally mine. 300 acres. No mention of any HOA. No easements. No restrictions. I made copies of everything and drove into Fredericksburg to the first law office I could find. The receptionist squeezed me in for a brief consultation that afternoon with one of their attorneys, a young guy named David Chen who looked fresh out of law school. "This is interesting," David said, studying the deed. "You have a recent survey." My grandfather had one done in 1995. "That's the most recent one I have. And you said they're claiming this property is part of an HOA." That's what the woman said. She showed me some map with a development called Silverdale Estates. David typed on his computer. "Okay, I'm looking at the county records now. There is a Silverdale Estates subdivision that was platted in 2009. It shows approximately 40 residential lots and a designated common area. But my land isn't part of that. My family has owned this property since the 40s. Let me check the legal descriptions." He clicked through several screens, his brow furrowed in concentration. "This is strange. The HOA plat does reference a parcel that matches some of the dimensions of your property, but the deed records clearly show continuous ownership in your family name. These are two conflicting claims in the public record. So what do I do? First, don't interfere with their construction." "What? They're destroying my land. I understand, but if you physically interfere, you could be arrested or sued. What we need to do is file an emergency petition for a temporary restraining order. We'll ask the court to halt construction until the property ownership can be properly determined. But I have to be honest with you, this is going to be expensive. Property disputes can drag on for months or even years." I felt sick. How expensive? My retainer for something like this would be $5,000, and the case could easily run $20,000 to $30,000 depending on how complicated it gets. I did not have that kind of money. The ranch was land rich but cash poor. I was living off my savings while trying to get a cattle operation started. "Can you at least file for the restraining order? I'll figure out the rest. I can start the paperwork, but I'll need that retainer before I can file anything with the court." I left his office feeling defeated. By the time I drove back to the ranch, 3 bulldozers were clearing cedar trees on the eastern section of my property. I watched from my porch as decades-old trees were pushed over and piled up. My grandfather had loved those trees. Over the next week, I scrambled. I called every attorney in Fredericksburg and the surrounding area. Most wanted retainers I could not afford. A few offered payment plans, but even those were beyond my budget. I contacted legal aid organizations, but they told me they only handled criminal cases or family law matters. Meanwhile, the construction continued. Every morning I woke up to the sound of heavy equipment. They brought in excavators, dump trucks, and grading equipment. The eastern portion of my ranch was being transformed into something unrecognizable. They cleared about 60 acres, reshaped the land into rolling fairways and greens, and began installing an irrigation system. Patricia Henderson showed up periodically to inspect the work. Each time I tried to confront her, she refused to engage. "My attorney has advised me not to speak with you," she would say, then turn away. I discovered that Silverdale Estates was a small development of high-end homes about 2 miles from my ranch. 40 families who had paid premium prices for lots in an exclusive community. According to their HOA website, residents had been promised a world-class 18-hole golf course as one of the main amenities. The website showed architectural renderings of a beautiful golf course with a clubhouse, pro shop, and restaurant. I drove over to Silverdale Estates one afternoon. The homes were massive Spanish-style estates with perfectly manicured lawns. The streets were private, with a guard gate at the entrance. When I tried to enter, the security guard stopped me. "I need to see ID and verification that you're visiting a resident," he said. "I need to speak with someone about the HOA. The HOA office is located inside the community. You'll need to be escorted by a resident. This is ridiculous. Your HOA is destroying my property." The guard's expression did not change. "Sir, if you don't have authorization to enter, I'll need to ask you to turn your vehicle around." I left, frustrated. That evening, I decided to do something I probably should have done from the beginning. I went to the Gillespie County Clerk's office and requested copies of every document related to Silverdale Estates and my property. The clerk, an older woman named Martha who had worked there for 30 years, helped me sort through the records. "This is peculiar," she said, flipping through pages. "The Silverdale Estates plat shows a parcel for the golf course, but the legal description is vague. It just says approximately 60 acres east of the main development, exact boundaries to be determined by survey." So they did not actually have a specific piece of land when they filed the plat. Apparently not. Usually, developers own all the land before they file a subdivision plat. This looks like they were planning to acquire land later. "Can they do that?" Martha shrugged. "I just record documents. Whether something is legal or not, that's for the courts to decide. But I can tell you that your deed is rock solid, clear chain of title going back decades. I remember your grandfather. He was a good man. So why hasn't the county stopped them? The HOA filed permits for construction on land they claim to own. The building department doesn't investigate ownership disputes. They just check whether the permits match the application." I left with a stack of copied documents and a new understanding of what I was facing. The HOA had essentially committed fraud. They had told their residents they would get a golf course, collected fees and assessments based on that promise, and then decided to build it on my land without my permission. But proving fraud and getting them to stop were two different things. That night, I sat at my grandfather's desk and read through everything carefully. My deed was straightforward. The Silverdale Estates documents were a mess of legal jargon, vague descriptions, and contradictory claims. But one document caught my eye. It was a title insurance policy from when the HOA had purchased the 40 residential lots from the original developer. The policy specifically excluded the proposed recreation area from coverage, noting that title to said parcel is unclear and requires additional research. In other words, even the title insurance company knew there was a problem with the golf course land. But the HOA had apparently ignored that warning and proceeded anyway. I made copies of everything and put together a chronological timeline. Then I did something that probably was not smart, but I was desperate. I created a Facebook account and joined several local Fredericksburg community groups. I posted about what was happening, including photos of the construction on my land and copies of my deed. The response was immediate and overwhelming. Dozens of people commented, expressing outrage. Several local news stations reached out for interviews. A reporter from the Fredericksburg Standard Radio Post came to the ranch the next day. Her name was Jennifer Wu, and she was thorough. She photographed the construction, interviewed me on camera, and took copies of all my documents. "This is a great story," she said. "Property rights are a big deal in Texas. People are going to care about this." The article ran 2 days later on the front page. "HOA builds golf course on private ranch without permission," the headline read. It was fair and balanced, including statements from both me and the HOA. Patricia Henderson was quoted as saying, We are confident in our legal position and look forward to resolving this matter in court." The article changed everything. Within hours, I received calls from 3 different attorneys offering to take my case. One of them, a property rights specialist named Robert Klein in San Antonio, offered to handle it on a contingency basis. "I don't usually take cases like this on contingency," Robert explained over the phone, "but what they're doing is outrageous. Plus, with the publicity, I think we can put real pressure on them to settle. If we win, I'll take 30% of any damages awarded, plus my costs. If we lose, you don't pay me anything except the filing fees and court costs." It was not perfect, but it was better than I could afford otherwise. I hired him the same day. Robert moved quickly. Within a week, he filed a lawsuit against the Silverdale Estates HOA, Patricia Henderson personally, and the construction company. The complaint alleged trespass, conversion, fraud, and several other claims I barely understood. He also filed an emergency motion for a temporary restraining order to stop the construction. The hearing was set for 2 weeks later. In the meantime, the story had spread beyond Fredericksburg. A San Antonio TV station ran a segment about it, then an Austin station. A property rights advocacy group in Houston called to offer their support. I even got a call from a producer at a national news show, though nothing came of that. The attention clearly bothered the HOA. I started receiving letters from their attorney, a firm in Austin called Warren and Associates. The letters demanded that I stop making defamatory statements to the media and threatened me with a lawsuit for tortious interference with contract. Robert laughed when I showed him the letters. "They're panicking. This is good for us." The day of the hearing arrived. The courthouse in Fredericksburg was a beautiful old limestone building in the town square. I met Robert in the hallway outside the courtroom. He was in his 50s, with silver hair and a calm demeanor that immediately put me at ease. "The HOA's attorney is here," Robert said. "Guy named Stephen Warren. He's going to argue that the HOA has a legitimate claim to the property based on the subdivision plat, and that you're causing irreparable harm to his clients by stopping construction." "That's insane." "I know, but he's going to try. Just stay calm and let me handle the arguments." We entered the courtroom. Patricia Henderson was there with Stephen Warren, a slick-looking guy in an expensive suit. Behind them sat several people I did not recognize, presumably members of the HOA board. The judge was a woman in her 60s named Judith Crawford. She had a reputation for being no-nonsense. "This is a hearing on plaintiff's motion for a temporary restraining order," Judge Crawford said. "Mr. Klein, you may proceed." Robert stood and laid out the facts methodically. He showed the judge my deed, the chain of title, the property tax records. He explained how the HOA had begun construction without my permission and how they had no legitimate claim to the property. "Your Honor, this is a clear case of trespass," Robert said. "The defendants have torn up 60 acres of my client's land, destroyed trees and vegetation, and fundamentally altered the landscape. All without permission, without compensation, and without any legal right to do so. We're asking this court to stop them before they cause even more damage." Judge Crawford turned to Stephen Warren. "Mr. Warren, what's your response?" Stephen Warren stood, his confidence evident. "Your Honor, this is not a simple trespass case. This is a complex property dispute involving competing claims that go back 15 years. The Silverdale Estates subdivision plat, which was properly filed and recorded with the county, includes the disputed parcel as a designated recreation area. When my clients' members purchased their homes, they did so with the understanding that this golf course would be built. They've paid HOA fees for years based on that promise. To stop construction now would cause irreparable harm to 40 families who have invested their life savings in these homes. You have a deed to the property, Judge Crawford asked. Not in the traditional sense, Your Honor. But the subdivision plat serves as, do you have a deed or not? No, Your Honor, but then on what basis are you claiming ownership? Stephen Warren pulled out a thick binder. Your Honor, if I may approach with these documents. The judge allowed it. For the next 20 minutes, Stephen Warren tried to argue that the subdivision plat, combined with various HOA bylaws and documents, gave his clients the right to the land. He cited several cases involving property disputes and easements. Judge Crawford listened patiently, then turned to Robert. Mr. Klein, response? Your Honor, Mr. Warren is trying to confuse the issue with legal technicalities. But the law is simple. My client has a deed. He has clear title. The defendants have neither. They cannot create a property right out of thin air by filing a subdivision plat. That's not how property law works in Texas or anywhere else. Judge Crawford nodded. I'm inclined to agree. Mr. Warren, unless you can show me some document that actually conveys property rights from Mr. Garrett or his ancestors to your clients, I don't see how they have any claim to this land. Your Honor, we believe there may have been an informal agreement between the previous generation. An informal agreement. Do you have anything in writing? We're still investigating, so that's a no. Judge Crawford looked at her notes. Here's what I'm going to do. I'm granting the plaintiff's motion for a temporary restraining order. All construction on the disputed property must cease immediately. The defendants are ordered to remove all equipment and personnel from the property within 48 hours. We'll schedule a preliminary injunction hearing for 3 weeks from now. At that hearing, Mr. Warren, you better come with more than vague references to subdivision plats and informal agreements. You need to show me actual evidence of a property right. Understood? Yes, Your Honor, Stephen Warren said, his jaw tight. I wanted to cheer but managed to keep my composure. Robert shook my hand as we left the courtroom. That went as well as we could have hoped, but don't celebrate yet. They're not going to give up easily. He was right. The HOA immediately appealed the judge's order, but the appellate court declined to overturn it. Construction stopped. The heavy equipment was removed. My land was left scarred and altered, but at least they were not making it worse. Then the HOA tried a different approach. A week after the hearing, I received a certified letter from Stephen Warren's office. Inside was an offer to purchase my entire ranch for $4 million. I called Robert immediately. They're trying to buy me out. That's not surprising. It's probably cheaper for them than fighting a long legal battle. Are you interested in selling? No. This land has been in my family for almost 80 years. My grandfather would roll over in his grave if I sold it to these people. Then we keep fighting. The preliminary injunction hearing was more of the same. Stephen Warren brought in a surveyor who testified that the boundaries were ambiguous. He brought in a real estate expert who claimed the HOA had equitable rights based on their investment in the property. He even tried to argue that because I had not objected immediately when construction began, I had somehow waived my rights. Judge Crawford was not buying it. She granted the preliminary injunction, making the construction ban permanent until the case went to trial. The trial was scheduled for 6 months later. Those 6 months were difficult. The HOA launched a PR campaign against me. They sent letters to all the Silverdale Estates residents painting me as an unreasonable neighbor trying to sabotage their community. Several residents wrote letters to the editor of the local paper calling me selfish and greedy. Patricia Henderson gave an interview to a San Antonio news station where she cried on camera about how I was destroying the dreams of 40 families. She conveniently left out the part about how she had built a golf course on someone else's land without permission. The HOA also started filing frivolous motions in court, trying to run up my legal bills and force me into a settlement. Every week there was some new motion to dismiss, motion to compel, or motion for some obscure procedural issue. Robert handled them all, but I could see the costs adding up. Then something unexpected happened. I received a call from a man named Richard Moss. He was a retired civil engineer who had done the original survey work for Silverdale Estates back in 2009. "I saw the news stories," Richard said. "I need to tell you something. When I did the survey for the developer, I specifically told them that the recreation area they wanted was not part of the land they owned. I told them they would need to acquire that parcel separately. They told me not to worry about it. You have any of this in writing?" "I have my field notes and my report to the developer. I kept copies of everything." This was huge. Robert immediately issued a subpoena for Richard's records and scheduled his deposition. In the deposition, Richard testified that he had explicitly warned the original developer that the golf course site was not included in their property. He had recommended they negotiate with my grandfather to purchase or lease the land. The developer had ignored his advice. "Did they ever tell you they had secured rights to that property?" Robert asked during the deposition. "No. In fact, at one point the developer told me to just mark it as TBD on the plat. I objected, but he was the client. TBD meaning to be determined, correct? So as far as you knew, they never actually obtained legal rights to that land, correct?" Stephen Warren tried to discredit Richard during cross-examination, but the man was unshakable. He had his original field notes, his survey data, and his professional reputation. He had no reason to lie. After the deposition, Robert was optimistic. "This is exactly what we needed. It shows they knew from the beginning they did not have rights to your property. That's going to help us prove fraud." The trial finally arrived in late November. The courthouse was packed. Local reporters filled the gallery. Some residents from Silverdale Estates showed up, glaring at me from across the aisle. The trial lasted 3 days. Robert presented our case methodically. He showed my deed. He walked through the chain of title. He presented property tax records showing continuous ownership by my family. He brought in Richard Moss to testify about the original survey. He even found the original developer, who had since moved to Arizona, and deposed him. The developer admitted under oath that he had always intended to work something out for the golf course land, but had never gotten around to it. Stephen Warren's case fell apart. He tried to argue that the subdivision plat created some kind of implied easement. He tried to argue that my family's failure to object to the initial plat, filing 15 years ago, somehow bound us. He tried to argue that the HOA had obtained rights through adverse possession, even though they had not been on the land for the required 10 years. Judge Crawford was clearly losing patience. During closing arguments, she interrupted Stephen Warren mid-sentence. "Counselor, I've listened to 3 days of testimony, and I haven't heard a single piece of evidence showing that your clients have any legal right to Mr. Garrett's property." "What am I missing?" Stephen Warren stammered through a response about equitable considerations and reasonable expectations, but it was clear he had nothing. Judge Crawford ruled from the bench. "I'm finding in favor of the plaintiff on all counts. The defendants have trespassed on Mr. Garrett's property. They have caused substantial damage to the land. They have no legal right or claim to the property whatsoever. I'm ordering them to restore the land to its original condition as much as possible, and I'm awarding damages to Mr. Garrett for the harm caused. We'll have a separate hearing on the amount of damages. This court is adjourned." I felt like I could finally breathe. Robert shook my hand, grinning. We won. But it was not over. The damages hearing took place 2 weeks later. Robert brought in a land restoration expert who estimated it would cost $300,000 to restore the damaged portion of my ranch. He also presented evidence of my emotional distress and the harm to my family's legacy. Stephen Warren argued that the damages should be minimal because the land had been improved by the grading and landscaping work. Judge Crawford actually laughed at that argument. "Mr. Warren, your clients destroyed 60 acres of this man's land without permission. They don't get credit for that." In the end, Judge Crawford awarded me $350,000 in damages, plus attorney's fees and costs. When added up, the HOA owed me nearly $500,000. The HOA's board held an emergency meeting after the verdict. I was not there, but I heard about it through the grapevine. The board voted to assess each homeowner in Silverdale Estates a special assessment of $12,000 to pay the judgment. The residents were furious. Within a month, several homeowners had filed a recall petition against Patricia Henderson and the other board members. They hired their own attorney to investigate how the board had allowed this disaster to happen. That investigation revealed that Patricia and 2 other board members had been warned by their original attorney that building on my land was risky, but they had proceeded anyway because they did not want to disappoint the residents. The recall effort succeeded. Patricia Henderson and the entire board were removed. The new board immediately settled all remaining issues with me. They paid the judgment in full, using a combination of the special assessment and a loan secured against the HOA's other assets. They also issued a formal apology, which was published in the local newspaper. But the story still was not quite over. Several of the homeowners in Silverdale Estates sued the original developer for fraud, claiming they had been sold homes with false promises about a golf course. That case settled out of court for an undisclosed amount. Patricia Henderson tried to sue the original developer herself, claiming he had misled the HOA board. That case was dismissed. Then came the part I had not expected. The new HOA board reached out to me through their attorney. They wanted to know if I would be willing to negotiate an actual legal agreement for a golf course on my land. I met with the new board president, a reasonable guy named Tom Richardson, who was a dentist in Fredericksburg. "Look, I know you have no reason to trust us after what happened," Tom said. "But our residents really did buy their homes expecting a golf course. We're willing to pay fair market value to lease the land, and we'll put everything in writing with proper legal documents." I thought about it. With the judgment money, I had funds to really get my cattle operation going. But 300 acres was more land than I needed, and if I leased 60 acres to them for a golf course, the lease income would provide steady cash flow. "I'll consider it," I told Tom, "but I'm not making any promises." I consulted with Robert and with a commercial real estate broker. We worked out a proposal. A 30-year lease at $20,000 per year, paid quarterly with built-in increases every 5 years. The HOA would be responsible for all maintenance and insurance. They would restore the land to my specifications first, then build the golf course according to plans I approved. And most importantly, everything would be documented with proper surveys, legal descriptions, and title insurance. The new HOA board accepted the proposal. We signed the lease agreement in January. The HOA spent the next 6 months properly restoring the damaged land, working with environmental consultants to replant native vegetation and restore the natural drainage patterns. Then they began construction on the golf course again, but this time with my permission and under my supervision. The golf course opened in November, nearly 2 years after Patricia Henderson's bulldozers first showed up on my ranch. It was beautiful, actually. The designers had worked with the natural topography, preserving as many of the old oak and cedar trees as possible. They built a modest clubhouse and a small pro shop. The residents of Silverdale Estates finally got their golf course, and I got a steady stream of income that allowed me to expand my cattle operation to the rest of the ranch. I still see some of the Silverdale Estates residents around town occasionally. Most of them are friendly enough now. They understand what happened was not my fault. A few still seem to blame me, but I do not care about those people. Patricia Henderson moved away about 6 months after she was recalled from the board. I heard she relocated to Arizona. I have no idea what she is doing now, and I do not care. The whole experience taught me several important lessons. First, always know exactly what you own and where your boundaries are. Second, document everything. Third, do not back down when you're in the right, even if it seems impossible. And fourth, there are still people in this world who think they can just take what they want without consequences. On quiet mornings, I still stand on my porch with my coffee and look out over my ranch. The golf course is visible in the distance, green fairways contrasting with the natural brush country. It is not what my grandfather would have envisioned, but he would be proud that I fought for what was ours. The land is still in the Garrett family. That's what matters. The cattle operation is doing well. I have about 100 head now, mostly Angus and Hereford crosses. The lease income from the golf course gives me financial stability while I build up the herd. I hired a part-time ranch hand, a local kid named Jesse who is studying agricultural business at Texas State. He reminds me of myself at that age, eager to learn and not afraid of hard work. Sometimes golfers who are playing near the property line will wave at me when I am out checking fences or moving cattle. I wave back. No hard feelings toward the residents. They were victims of Patricia Henderson's arrogance as much as I was. I ended up using some of the judgment money to build a new barn and renovate the old ranch house. My grandfather's house was solid but needed work. I updated the kitchen and bathrooms but kept the character intact. The original wood floors, the stone fireplace, the hand-hewn beams in the ceiling. I wanted to honor his memory by taking care of what he built. Robert Klein and I became friends through the whole ordeal. He comes out to the ranch periodically to fish in the stock tank and drink beer on the porch. He never charges me for the occasional legal advice I need. He says representing me was one of the most satisfying cases of his career. "You stood up to bullies," he told me once. "That's rare these days. Most people would have given up or settled for pennies." Maybe he is right. I do know that if I had not fought, I would have lost everything my family built. The ranch would have been swallowed up by the HOA's arrogance and incompetence. Instead, it is still here, still in my name, still producing. I thought about writing a book about the experience, but I am not much of a writer. I did give a few interviews to property rights organizations, and my case has been cited in several legal journals as an example of HOA overreach. Apparently, what happened to me is not as rare as you might think. HOAs across the country regularly exceed their authority, violate property rights, and bully homeowners. Most people do not have the resources or the determination to fight back. The local paper did a follow-up story a year after the trial. The headline was, "From Courtroom Battle to Peaceful Coexistence: How One Rancher and an HOA Found Common Ground." It was a nice story, though it glossed over how difficult the fight had been. The reporter made it sound like we all just worked out our differences through reasonable discussion. That was not quite accurate, but I let it go. I also got some attention from the agricultural community. The Texas and Southwestern Cattle Raisers Association gave me an award for defending property rights and upholding the legacy of Texas ranching. It was a nice ceremony in Fort Worth, and I got to meet other ranchers who had faced similar battles with developers, government agencies, and HOAs. One rancher from near Waco told me his story. A municipal utility district had tried to claim an easement through his property without compensation, saying they needed it for a water line. He fought them in court for 3 years and eventually won, but it cost him nearly $100,000 in legal fees and lost productivity. "Property rights are under assault," he said. "We have to stand up for them or we'll lose everything." I understood exactly what he meant. The right to own property, to control it, to exclude others from it, these are fundamental rights that go back centuries. When entities like HOAs, government agencies, or corporations think they can just take what they want, they are undermining the foundation of our society. But I did not want to become bitter or paranoid. I won my fight. My property is secure. The ranch is thriving. I tried to focus on the positive. One unexpected benefit of the whole situation was that I became somewhat well known in the Fredericksburg area. People recognized me at the grocery store or the feed supply. Most were supportive. A few wanted to tell me their own stories of fighting HOAs or other organizations. I listened politely, but tried not to get too involved in other people's disputes. I had my own ranch to run. I also started dating someone, which I had not really done since moving to the ranch. Her name was Fiona Nelson, and she was a veterinarian in Fredericksburg. We met when I called her out to check on a sick calf. She was smart, funny, and did not care about the whole HOA drama. Well, she cared in the sense that she thought what they did was outrageous, but she did not define me by it. We were just two people who enjoyed each other's company. Fiona grew up on a ranch near San Angelo, so she understood the lifestyle. She did not mind the early mornings, the hard work, or the fact that my hands were usually dirty. We started spending more time together, and by the following spring, she had moved into the ranch house with me. Having her there changed everything. The house felt like a home again instead of just a place I was staying. We cooked dinner together, sat on the porch in the evenings, made plans for the future. She brought her 2 dogs, a pair of Australian shepherds that immediately took to ranch life and became invaluable for working cattle. We talked about getting married, but we were not in a rush. We were both in our early 30s and had learned that good things take time. Besides, we were already building a life together. A piece of paper would not change how we felt about each other. The golf course continued to operate successfully. The HOA hired a professional course manager, and they kept the place in good condition. They held tournaments and events, and it became a nice amenity for the community. Some of the golfers even stopped by the ranch house occasionally to buy beef directly from me. I started selling quarter-and-half cows to people in Fredericksburg and nearby areas, building up a customer base of people who wanted to know where their food came from. Tom Richardson, the HOA president who had negotiated the lease with me, became a regular customer. He and his wife bought a quarter cow twice a year. "Best beef I have ever had," he told me. "Grass-fed, locally raised, and I know the guy who raised it. Can't beat that." It was funny how things worked out. The people who had tried to steal my land ended up becoming customers and, in some cases, friends. I never forgot what Patricia Henderson did, though. Sometimes I wondered what she was thinking when she ordered those bulldozers onto my property. Did she really believe the HOA had a right to the land? Or did she know she was stealing but figured I would not fight back? I will never know, and it does not really matter. She lost and I won. That's the end of the story, except it was not quite the end. About 2 years after the trial, I received a call from an attorney in Arizona. Patricia Henderson had apparently learned nothing from the Texas experience. She had become president of an HOA in Scottsdale and was facing multiple lawsuits from homeowners there for various abuses of power. The attorney wanted me to testify as a character witness to establish a pattern of behavior. I declined. I had no desire to relive that period of my life or to deal with Patricia Henderson again. Let the Arizona homeowners fight their own battles. I had moved on. Life on the ranch settled into a comfortable rhythm. Spring meant calving season, long days and nights making sure the cows and their babies were healthy. Summer meant managing the heat, making sure the stock tanks stayed full, moving cattle to fresh pasture. Fall meant weaning the calves and taking them to market. Winter meant maintaining equipment, fixing fences, and preparing for the next year. Fiona's veterinary practice kept her busy, but she helped on the ranch whenever she could. She was good at reading cattle, knowing when something was off with an animal before it became a serious problem. We made a good team. We also expanded the ranch operation slightly. I leased another 100 acres from a neighbor who was getting too old to manage it himself. That gave us room to expand the herd to about 150 head. The additional cattle, combined with the golf course lease income and Fiona's veterinary income, gave us a comfortable living. We were not rich, but we were not struggling either. I thought about my grandfather often. He had worked this land for decades, through droughts and recessions, dealing with predators and market fluctuations and all the other challenges ranchers face. He never had to deal with an HOA trying to steal his land, but I think he would have handled it the same way I did. Stand your ground. Fight for what's right. Never back down. The old-timers in Fredericksburg sometimes told me stories about my grandfather, how he was always willing to help a neighbor, how he never cheated anyone, how he loved the land and respected it. Those stories meant more to me than any award or recognition. I tried to live up to his example. When a young couple wanted to start a small farm on some land adjacent to mine, I helped them get set up, loaning them some equipment and giving them advice. When the local 4-H chapter needed a place to practice showing cattle, I let them use one of my pastures. When a conservation group wanted to do a habitat restoration project on some marginal land I was not using, I worked with them to make it happen. Fiona and I talked about having kids someday. We wanted to raise them on the ranch, teach them the value of hard work and respect for the land. We wanted to continue the legacy that my grandfather started, but we were not in a rush. We were enjoying our life together, building our operation, making our place better year by year. The golf course lease came up for renewal after 5 years. The HOA board asked if we could negotiate a longer-term extension, maybe another 25 or 30 years. They had invested a lot in the course and wanted security. We negotiated a new 40-year lease with better terms for both sides. I got a higher annual payment with inflation adjustments. They got the long-term security they wanted. Robert Klein reviewed all the documents, and we signed the new lease in March. That lease money allowed us to make some major improvements to the ranch. We drilled 2 new water wells. We built a modern cattle working facility with hydraulic chutes and sorting pens. We upgraded the fencing on the entire property. We bought a newer tractor and some additional equipment. All things my grandfather would have loved to do but never had the resources for. We also set up a conservation easement on part of the ranch, protecting it from future development. That was important to both Fiona and me. We wanted to make sure that even after we were gone, this land would remain as open space, supporting cattle and wildlife and the natural ecosystem. The local land trust helped us structure the easement in a way that gave us some tax benefits while permanently protecting the land. It was a win-win situation. We got some financial relief, and the land got protected forever. I sometimes drove past Silverdale Estates and looked at those big houses with their perfect lawns. The people who lived there had very different lives from mine. They worked in San Antonio or Austin, commuting every day, living in their suburban bubbles. I did not judge them for it. People want different things from life, but I knew I had made the right choice. The ranch was where I belonged. Working with animals and land, dealing with weather and seasons, being part of something bigger than myself. That was the life I wanted. Fiona felt the same way. She loved her work as a veterinarian, but she also loved coming home to the ranch, to the peace and space and freedom. We would sit on the porch in the evenings and watch the sunset, the sky turning orange and pink and purple over the hills. Those were the moments that made everything worthwhile. We eventually did get married, in a small ceremony on the ranch with about 50 friends and family members. Robert Klein was there, of course. Tom Richardson from the HOA came. Some of our ranching friends. Fiona's family from San Angelo. My aunt from Houston, my only close relative. We said our vows under an old oak tree near the house, the same tree where my grandfather used to sit and watch the herd. It was a perfect day. Simple, authentic, meaningful, just like our life together. The cattle operation continued to grow. We developed a reputation for quality beef, and we had more customers than we could supply. We started working with a couple of local restaurants in Fredericksburg, providing them with beef raised right here in the county. The chefs loved having a reliable local source, and we loved having steady customers. We also started doing some agritourism, hosting small groups for ranch tours and educational programs. City folks were fascinated by ranch life, and we enjoyed sharing our knowledge. We taught them about cattle breeding, grass management, predator control, water conservation. We showed them how much work goes into producing the food they eat. Most people had no idea. The ranch became more than just a place where we raised cattle. It became a community resource, a place where people could connect with the land and learn about agriculture. My grandfather would have loved that. I still think about that morning when I saw the first bulldozer roll onto my property. It feels like a lifetime ago, though it was only a few years. That moment changed everything. If I had not stood up to the HOA, if I had let them intimidate me, I would have lost the ranch. Instead, I fought and I won, and I built something even better than what I started with. The experience taught me that sometimes you have to fight for what's right, even when the odds seem impossible. You have to believe in yourself and your cause. You have to be willing to take risks and make sacrifices. And you have to surround yourself with good people who will support you. Robert Klein, Richard Moss, the journalists who covered the story, the people in the community who stood by me, they all played a role in the outcome. I did not win alone. I won because good people helped me. That is another lesson I learned. You need allies. You need people who will stand with you when things get tough. You need experts who know what they are doing. You need a community that values justice and fairness. I tried to be that kind of ally for others. When I heard about someone facing a similar situation, I reached out and offered advice, connections, moral support. I could not fight their battles for them, but I could help them understand what they were up against and how to navigate the system. Several people told me I should go into politics, maybe run for county commissioner or some other local office. I declined. I was not a politician. I was a rancher. My place was here, working the land, raising cattle, living the life my grandfather lived. But I did get more involved in local issues. I joined the County Farm Bureau. I served on the board of the local land trust. I testified at county commission meetings when there were issues affecting agriculture or property rights. I tried to use my experience and my voice to make a difference. Fiona did the same in her own way. She volunteered with the animal shelter. She did free or reduced-cost veterinary work for people who could not afford it. She mentored young people interested in veterinary medicine. We both believed in giving back to the community that had supported us. As I write this, sitting at my grandfather's old desk in the ranch house, I can hear Fiona in the kitchen making dinner. The dogs are asleep on the porch. The cattle are out in the pasture, grazing in the evening light. In the distance, I can see a few golfers finishing their round on the course that nearly destroyed my life but ended up becoming part of our success. It is a good life. Not always easy, but good, meaningful, connected to something larger than myself. Connected to the land, to the community, to the past and the future. My grandfather bought this ranch in 1947 with money he saved working oil fields and doing odd jobs. He built it from nothing, clearing brush, building fences, buying a few head of cattle at a time. He raised my father here, teaching him the values of hard work and integrity. My father inherited the ranch and continued the tradition, though he never loved it the way my grandfather did. When my father died and left the ranch to me, I felt the weight of that legacy. I almost lost it all because of an arrogant HOA president who thought she could take what was not hers, but I did not lose it. I fought back and I won, and now the ranch is stronger than ever. The land is still here. The cattle are still here. The legacy continues. That is what matters. I have added my own chapter to the ranch's story, a chapter about fighting for what's right and protecting what matters. Someday, if Fiona and I have children, they will add their own chapters. The story will continue, generation after generation, as long as we protect the land and honor the legacy. That is the real victory, not the court judgment or the money or the recognition. The real victory is that the Garrett Ranch survives and thrives, that my grandfather's dream continues, that the land he loved is still here for future generations. I saved the deed that was at the center of the court case. It hangs in a frame on the wall of the office, a reminder of how important those pieces of paper are, how much they represent. Property rights are not abstract legal concepts. They are the foundation of everything we build, everything we create, everything we pass on to our children. When Patricia Henderson tried to take my land, she was not just threatening me. She was threatening my grandfather's legacy, my family's history, and the fundamental principle that you cannot just take what belongs to someone else. The court understood that. Judge Crawford understood that. The law protected me because I had the deed, the clear and unambiguous proof that this land was mine. I will never take that for granted. I will never assume that just because something is right, it will work out. I learned that you have to fight for what's right, and you have to have proof, and you have to be willing to stand up to bullies no matter how powerful they seem. The sun is setting now. Fiona is calling me to dinner. The dogs are stretching and getting ready to come inside. Another day on the ranch is ending and another will begin tomorrow. The cattle will need to be fed and checked. The fences will need to be inspected. The water tanks will need to be monitored. The endless cycle of ranch work continues, but it is not a burden. It is a privilege. I get to live on this beautiful land, do meaningful work, and carry on a legacy that matters. Not many people can say that. The golf course sits quietly in the distance, its greens and fairways maintained by HOA funds, generating lease income that helps support everything we do here. The irony is not lost on me. The very people who tried to steal my land are now paying me to use it. Justice has a sense of humor sometimes. I have told this story to help others understand what can happen when HOAs or other entities exceed their authority. I have told it to encourage people to stand up for their rights. I have told it to honor my grandfather and the legacy he left me. But mostly, I have told it because it is true. It really happened. An HOA really did build an 18-hole golf course on my ranch without permission. I really did let them finish before I showed my deed in court. And I really did win, protecting my family's land and continuing the legacy that matters more than anything else. That is my story. That is how a man and his deed defeated an arrogant HOA and saved a legacy. That is how justice prevailed, even when it seemed impossible. And that is how the Garrett Ranch survived and thrived, ready for whatever challenges the future might bring.